Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. You have been asked to come to court today for what we call arraignment. And what the arraignment is, it's an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. Now, the case that you have in this court is a criminal case. Criminal cases are divided into felonies or misdemeanors. And the case that you have is a misdemeanor case. Felony cases are divided into 5 categories. Misdemeanor cases are divided into 3 categories. Your felony cases are commonly referred to as your most serious type of criminal offenses, whereas your misdemeanor cases are referred to as petty offenses. Does not mean that they're not serious. It just means that they're not as serious as a felony case. And when I use the term serious, what I'm talking about the facts of the case or the circumstances and the possible punishment that a person can receive if they are convicted of the offense. Now, as I mentioned earlier, felonies are divided into 5 categories. We'll start at the top and work our way on down to the bottom. You have the capital murder, first-degree felony, second-degree felony, third-degree felony, and the state jail felony. If a person is convicted of a state jail felony, the range of punishment is minimum 2 years in the state jail and a fine that does not exceed $10,000. If a person is convicted of a third-degree felony, the range of punishment is minimum 2 years in the state penitentiary and a fine that does not exceed $10,000. If a person is convicted of a second-degree felony, the range of punishment is minimum 2 years to maximum 20 years in the state penitentiary and a fine that does not exceed $10,000. If a person is convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years to life in the state penitentiary and a fine that does not exceed $10,000. Now, if a person is convicted of a capital murder, which is the highest felony that we have in Texas, the range of punishment is minimum life in the state penitentiary without the possibility of parole or death by lethal injection. Now, as I mentioned to you earlier, your case is a misdemeanor case, so you don't have to worry about the felony punishment. And felonies and the misdemeanors, rather, are divided into 3 categories. We'll start at the top, work our way on down to the bottom. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. Now, normally your Class C misdemeanors are cases that are handled in the Justice Court or the JP Court, or they are handled in the city court or the municipal court. Now, if a person is convicted in the JP court or a municipal court of a Class C misdemeanor, then they will appeal the case and the case comes to this court and you get a whole new trial. Now, the punishment range is still the same. It's fine only. You cannot be given jail time for a Class C misdemeanor, and the fine range is $0 to $500. Now, however, if a person fails to pay the fine, or if the fine was converted to community service and the person fails to perform the community service, then the court can issue what is called a capias pro fine. And basically, that's a warrant for the rest of the individual to either pay the fine or sit the fine out in jail. Now, a person, if they sit the fine out in jail, they will receive $100 credit for every day that they sit in jail. The credit will go toward the fine and court costs. Now, the next highest misdemeanor is a Class B misdemeanor. The range of punishment for a Class B misdemeanor is minimum 0 days to a maximum of 180 days, which is 6 months in the county jail, or a fine from $0 to $2,000, or you could be given both such confinement and fine. Now, if a person is convicted of a Class A misdemeanor, the range of punishment is minimum 0 days to a maximum of 365 days in the Jefferson County Jail, which is a year or 12 months, a fine from $0 to $4,000, or the person could be given both such confinement and fine. Now, a person may be eligible for probation. There are two types of probation. One type of probation is called unadjudicated probation. Unadjudicated probation. And with that type of probation, the person does not get a conviction on their record. And if they successfully complete the probationary period, the case will be dismissed and they may qualify for what is called a non-disclosure. Non-disclosure basically means that your record is sealed to the general public. That is, the general public cannot have access to the person's criminal record. However, the government can, or any type of governmental entity can have access. So it could be the federal government, state government, city government. So any type of government agency, department, or office can have access to the record. So most of the public is just the general public, and so most people will not have access to your criminal record if you get a non-disclosure. Now, the other type of probation is called adjudicated probation. So we have unadjudicated probation and adjudicated probation. And with adjudicated probation, you do have a conviction on your record once you get on probation. However, there's something that is called judicial clemency. That means that the court or the judge can set aside your conviction. Now, and then if the court or the judge set aside your conviction, you will not have a conviction on your record. Now, in order to qualify for judicial clemency, you have to successfully complete the probation. There cannot be any more time left on the probation, and you have to be successfully discharged off of probation. And so once those three things happen, then the court in its discretion can set aside your conviction. And if your conviction is set aside, you will not have a conviction on your record. Now, however, if you get a subsequent conviction, or if you get another conviction later on, then the case that you received judicial clemency on can be resurrected, brought back up, and used against you. And if you try to get a license with CPS, they could deny giving you a license. Or if you have a license, they could suspend or revoke that license. Now, as a defendant in a criminal case, you have rights. And we're going to talk about the rights that you have, some of the rights that you have as a defendant in a criminal case. One right that you have is a right to have a trial by jury. Now, the clipboard that you have, there should be a document on that clipboard that is titled Judge's Explanation of Rights to Defendants Without Attorney. And you can just turn to that page. I'm going to go over that document with you. Now, on that document, it says, as a defendant in a criminal case, you have three options regarding your right to have an attorney. Number one, you may hire an attorney. Number two, you may request that an attorney be appointed to represent you. Or number three, you may represent yourself. Now, if you have enough money to hire an attorney, you would like to hire your attorney, your case will be reset. Reset means that you'll be given another court date to give you time to hire your attorney. Now, if you want an attorney, but you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. And you would have to fill out a financial questionnaire. The financial questionnaire is also a document that is on the clipboard. That document is titled Jefferson County Affidavit of Indigence. Now, just turn to that document right quick. On that document, for those of you who will be requesting a court-appointed attorney, you will have to fill out the first page and then half of the second page. And then the court will fill out the bottom of the second page and the third page. All right. Now let's go back to the first document, judge's explanation of rights to defendants without an attorney. And it states that you may speak to a prosecutor if you are waiving your right to an attorney. Now, if you want to waive your right to an attorney, that is, give up your right to an attorney and represent yourself, then you will have an opportunity to talk to the prosecutor, attorney Andrew Hubel, who's sitting in the chair and the table in front of you. You would have an opportunity to talk to him about your case to see if you can work out a settlement on your case. Now, you cannot talk to him unless you first sign a waiver of counsel. Now, the waiver of counsel is a document that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. Now, for those individuals who will be representing themselves, they're waiving their right to an attorney, which means giving up their right to have an attorney to represent, and they would like to represent themselves, then they would have to read and sign that document, and then they'll have an opportunity to talk to Mr. Andrew Hubel about their case. Now, you should be aware that there are dangers and disadvantages to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, if you choose to waive your right to have an attorney and you would like to represent yourself, you may change your mind at any time. And if you change your mind, you can ask for an attorney to be appointed to represent you. Now, at the bottom of that first document, Judge's Explanation of Rights to Defendants Without an Attorney, you'll see 5 lines to the left. And it basically said, and also above those lines, it says in bold print, defendant's choice. Mark your initials next to only one choice. Now, if your choice is to hire your own attorney, then you'll place your initials on the first line to the left. If you have already hired an attorney to represent you in your case, then you will place your initials on the second line to the left. If your choice is to request that an attorney be appointed to represent you, then you will place your initials on the third line to the left. If you have already been appointed a court-appointed attorney to represent you in your case, then you will place your initials on the fourth line to the left and the name of the attorney on the line to the right. If you like to waive your right to have an attorney, that is, give up your right to have an attorney and represent yourself, then you will place your initials on the fifth line to the left. Now, once you finish initialing one of the 5 lines, you will sign your name on the line at the bottom of that document that is titled Defendant, and you will date it today's date, July 16th of 2024. Now, for those individuals who will be waiving their right to have an attorney, that is, you'll be giving up your right to have an attorney you would like to represent yourself. As I mentioned to you earlier, you would have to sign the document that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. And you'll see on that document, it states that I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Now, when it says voluntarily, that basically means that no one is forcing you to enter into or to sign this form. And when it says intelligently made, it says that you know what you're doing. So it says that my waiver is voluntarily and intelligently made. Furthermore, I have been advised this 16th day of July 2024 by County Court at Law Number 2 of my right to have an attorney appointed to represent me. Now, I have been further advised that if I'm unable to afford counsel, one will be appointed to me free of charge. Understanding my right to have counsel appointed to me free of charge, if I'm not financially able to employ counsel, I wish to waive that right and request that the court proceed in my case without an attorney being appointed to represent me. Now, if that is your choice, then you will sign your name on the line that is titled defendant, and you will date it today's date, July 16th of 2024. Now, as I mentioned to you earlier, you have other rights. Another right that you have is a right to have a trial by jury. Where those young ladies are sitting in that area over there, we call that the jury box. 6 citizens from Jefferson County will be selected to serve as jurors in your case. They will listen to all of the evidence that's being presented. They will listen to all of the arguments from both the state and the defense, and then they will retire to the jury room. They will deliberate, and then they will decide to find you either not guilty or guilty of the offense. Now, Ms. Mosby, come here. Okay. Now, as I mentioned to you earlier, you have a right to have a jury trial. Now, you also have a right to waive or give up your right to have a jury trial. That simply means that you have a right not to have a jury trial. Now, if you waive or give up your right to have a jury trial, your case will come before the court in one of 3 ways. One way it can come before the court is by way of a trial. Somebody might ask, well, how can it come before the judge by way of a trial if I'm waiving my jury trial? Well, it will come before the judge by way of a bench trial. A bench trial means that it's a trial by judge only. The judge will be the judge and the jury in the case. The judge will listen to all of the evidence, listen to the arguments. The judge will apply the facts to the law and then decide whether to find you guilty or not guilty. Now, you also have a right to waive or give up your right to have a bench trial. Now, when you waive or give up your right to have a trial, whether it's a jury trial or bench trial, that basically says that the person is going to be pleading either guilty or no contest. If a person pleads guilty, what the person is saying that they're saying basically that they committed the offense that they have been charged with. Now, if a person pleads a no contest, they're saying that they will not be fighting the charges or they will not be contesting the charges. Now, they also have a right to plead not guilty, and if they plead not guilty, obviously they're saying that they want a trial either by judge or by jury. So if they plead not guilty, they have a trial by judge or jury. If they plead guilty and no contest, then the other way that would come before the judge, the second way is by way of what we call a plea bargain agreement. It could be what we call an unagreed plea bargain agreement. Unagreed, well, first of all, a plea bargain agreement means that the person or the defendant and the state, which is the district attorney's office, have reached an agreement to settle. It's an agreement to settle the case. That's what a plea bargain agreement is. Now, if you do not have a plea bargain agreement to settle the case, we call that an unagreed plea bargain agreement. So if the case comes before the judge the second way, by way of an unagreed plea bargain agreement, it means that the defendant and the state have not been able to reach an agreement and they still want to plead no contest or guilty, but they want the judge to decide what the punishment will be. Now, the third way that the case can come before the judge is by way of an agreed plea bargain agreement. That means that the state and the defense have reached an agreement regarding the punishment in the case, and the case will come before the judge, and the judge can do one of two things. The judge can either accept or reject the plea bargain agreement. Now, if the judge rejects the plea bargain agreement that you've entered into with the state, you have a right to take your plea back. In essence, you have a right to say, well, judge, since you're not accepting my plea bargain agreement with the state, I withdraw my plea of guilty or I withdraw my plea of no contest. You have a right to do that. And then we go back to square one. Now, if the judge does follow the plea bargain agreement, then at that point, if you decide later on, when I say later on, within 30 days of the plea bargain agreement, if you decide within 30 days of the plea bargain agreement that you would like to appeal your case, that is, you would like to have a higher court than this court to look at the case because you think that you've been wrongfully convicted or this court committed an error by convicting you. And if you like to appeal your case, then you have to get permission from the judge that followed the plea bargain agreement. Now, if the judge gives that permission, the case will leave this court and go upstairs to the Ninth Court of Appeals. They will review your case to see whether or not this court committed an error by convicting you or whether or not you were wrongfully convicted. They can do one of two things. They could either grant or deny your appeal. If they grant your appeal, they can simply find you not guilty. Or they can send the case back down to this court and order this court to give you a whole new trial. Now, if they deny your appeal, then you can appeal your case to a higher court than the Ninth Court of Appeal. You can appeal your case to the highest criminal court in the state of Texas. The highest criminal court in the state of Texas is the Texas Court of Criminal Appeals located in Austin, Texas. Now, you would have to file what is called a pro se petition for discretionary review. And I'll explain that to you. Pro se means that you'll be representing yourself and petitioning the Texas Court of Criminal Appeals to review your case to see, one, whether or not your appeal should have been granted, two, whether or not this court wrongfully convicting you or committed an error by convicting you. They can do one of two things. They can either grant or deny your pro se petition. If they grant your pro se petition, they can simply find you not guilty. Or they could send the case back to the Ninth Court of Appeals, or they could send the case back down on this court and order this court to give you a whole new trial. Now, if they deny your pro se petition for discretionary review, then at that point, your conviction will stand. Now, also as a defendant in a criminal case, you have a right to have witnesses to come to court and testify. They sit in that chair over there that has the microphone in front of it. We call that the witness stand. They can, when I say they, I'm talking about witnesses, they can either testify for you or against you. If you're representing yourself, you can ask them questions. You have a lawyer, your lawyer can ask them questions. We call it either direct examination or cross-examination. You also have a right to waive or give up your right to have witnesses to come to court. That simply means that in your trial, you will not be calling witnesses. It does not mean that the state will not be calling witnesses, because the state will be calling witnesses in the case that they have against you. You also have a right to have what we call discovery. Discovery means you have a right to see the evidence that the state has against you, all of the evidence that the state has. You have a right to have access to it. You have a right to see your statement, witness statements, police reports, lab reports, photos. You have a right to listen to audio recordings, see video recordings. You also have a right to have access to any type of instruments that they may have. Now, you also have a right to waive or give up your right to have discovery. And that means that you have a right not to see the evidence that the state has against you, if that's your desire. Now, everyone that's here today, you're here today because you were arrested and you're out of jail on bond. You're either out on what is called a cash bond, which means you paid the full amount of the bond to get out of jail, or maybe you're out of jail on a surety bond, which means that you paid a bondsman a percentage of the bond to get out of jail, or you're out of jail on a PR bond or a personal recognizance bond, which means that you did not have to pay any money to get out of jail. You just was released under your own personal recognizance with a promise to appear here in court. Now, every day that you spent in jail, whether it be 1 minute or more, you can receive credit for that time. Now, I use the term day because even if you were arrested, let's say at 11:59 p.m., okay, you booked into jail at 11:59 p.m., and then you bonded out at 12:01 a.m. the next day, which means you would stay in jail 2 minutes. But guess what? That 2 minutes was 2 different days, so you get credit for 2 days. All right? So every day that you spent in jail, it can be used as credit towards your punishment. So, for example, let's say you in the state have reached a plea bargain agreement, and you've served 5 days in jail, and the agreement that you reached is for you to serve 5 days in jail. It does not mean that you have to serve any more time in jail because you've already served 5 days in jail. Therefore, you'll be given credit for the time that you have already served. Now, every day that you spent in jail can also be used as credit toward your fine and court costs. You receive $100 per day that will be credited toward your fine and court costs. And so if you spend 5 days in jail, and let's say you and the state have reached a plea bargain agreement for you to pay a $500 fine, well, you won't have to pay anything because you spent 5 days in jail. That's $500. It will be taxed and retired. And so therefore, you would not have to pay because the time that you spent in jail has already paid it off. Now, if the state says, well, I want you to serve 7 days in jail and you have 5 days in jail, that means you only have to serve 2 more days in jail. Or if the state tells you that you have to pay $700 and you serve 5 days in jail, which is $500, you would only have to pay $200. Now, if you can't pay the $200 on the day of the plea, then that's not a problem because we could put you on a payment plan, which means you could pay it off in monthly installments until it's fully paid. Now, for those individuals who do not have the income or the job to pay off the fine and court costs, well, that's not a problem either because we can convert the fine and court costs to community service. And what community service is, you'll work at a nonprofit organization in Jefferson County, and every 1 hour that you work, $12.50 will be credited toward your fine and court costs. So if you work a 8-hour day, that's $100 that will be credited toward your fine and court costs. And so if you owe $200, you work 2 8-hour days, then that will be $200 that will be credited toward your fine and court costs. Now, Jefferson County has a program for first-time offenders. If you haven't been in trouble before, this is your first time here, well, Jefferson County has a program where they will dismiss your case and you can get it wiped off your record. And the way it works, well, first of all, it's called pretrial diversion. And the way pretrial diversion works is if it's your first time getting into trouble and the offense is not unlawfully carrying a weapon or resisting arrest, and you have an attorney that can help you to fill out the application to get into the program, then what they will do is once you get into the program, the case will be dismissed. Once you finish the program, you can get an expunction, which means to wiped off, deleted, or erased from your record. And so, as I mentioned, if you're a first-time offender, you're interested in that program, you like to get it off your record. And when I say off your record, somebody look up your record. Once you get an expunction, they won't see anything because it's gone. It's been erased or deleted or wiped off from your criminal record. Now, if you are a veteran of any one of the branches of the United States military, Jefferson County District Attorney's Office also has another program that is called Veterans Court. And with the Veterans Court program, the only way to qualify is basically you veterans. And so you could get into the program. Once you get into the program and complete the program, the case will be dismissed and you could qualify for a non-disclosure. And as I mentioned to you earlier, what a non-disclosure is, it basically means that your record will be sealed to the general public. The general public cannot have access to your record. All right. Now, this court has a program that is called the CSI program. CSI stands for Community. It's an acronym that stands for Community Safety Initiative. And that program is a program that I started in March of 2017 within the first 100 days of taking office. That program is designed to address the issue of what we call recidivism. Recidivism means where people commit crimes over and over. And so the way we address it is through the CSI program. Now, we have partnerships with local agencies. One of the agencies that we have a partnership with is the Spindletop Center. Spindletop is our local mental health center in the Southeast Texas region. And what Spindletop can do, they have the expertise to address any mental health issues that you may have. Now, Spindletop, we have some individuals who hear from Spindletop. They will come to you in a few minutes and tell you more about the program. Now, just a little bit about the program. They will have the ability to do what? An interview. The interview is a private interview that can be conducted either in our jury room or one of the jury rooms, or it could be conducted at their facility, or they might want to do it by phone, depending on whatever is convenient for you. Now, they also can do an assessment. They can develop a treatment plan, either outpatient or inpatient treatment, to address your mental health needs. Now, in order to participate in the program, you do not have to be incompetent or insane. You could just merely suffer from anxiety or depression or any other host of mental illnesses, and they have the expertise to address your mental health needs. Spindletop also has a program that has the acronym ATAR. ATAR stands for Addiction, Treatment, and Recovery. Now, we also have a partnership with our local Drug and Alcohol Council that has a program that is called OSAR, OSAR, that stands for Outreach, Screening, Assessment, and Referral. Now, both ATAR and OSAR are drug and alcohol recovery programs. With those programs, they will do a screening, an assessment, and a referral for either outpatient or inpatient treatment, depending on your drug and alcohol needs. If you are unemployed or if you're looking for a better job, well, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that's called CICE. That's an acronym that stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, and the chemical industry. Now, once an individual is trained in any one of those areas that they select, then they will assist them at getting a job in the area that they are trained in. Now, if you have not graduated from high school or have not received your GED, well, CICE also has a GED program, a graduate equivalency, where you can receive your graduate equivalency diploma. Now, all of these programs that I just mentioned to you will not cost you anything. They're free. The only thing it will cost you is just some time. And I like to say in this court, we don't just give time, we take our time. That means we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people, because if we produce productive people will not commit crimes because they have too much to lose. So I say, when you come to county court at law number 2 of Jefferson County, Texas, we do not just have court as usual, we have unusual court. And it's not because we're different, but it's because we are trying to make a difference in the lives of the individuals that come before this court. And if we make a difference in their life, then we will make a difference in their home. And if we make a difference in their home, we will make a difference in the community, because what comes out of the home goes into the community. So if you're interested in any one of these programs, just let us know. And we have brochures and information that we can give to you so that you can get into any one of these programs that I previously mentioned. Now, at this time, We will have the folks from Spindletop who's going to come before us. We have Chloe, Chris, and Deputy Hinton. They're going to come before you and tell you a little bit more about the program that Spindletop has to offer.
Thank you.
You're welcome.
Good morning. My name is Steve Hinton. I'm a mental health deputy licensed at the Texas Commission here with Sheriff. I'm here with my two coworkers, Chris and Chloe. Both these ladies are qualified mental health professionals. The reason all three of us are here this morning is because the judge cares about every single person that comes before the bench. What the judge has found, it was statistics prove that those who have legal issues commonly have mental health needs, substance use disorders, or sometimes just a lack of community resources to help you with a particular situation.
So, as the judge mentioned earlier, a lot of times what we see is anxiety, depression, right? It's not necessarily something outside, but every person deals with it at some point in their lives, right? We have to exclude us, we all know this, this is not an environment that really helps with anything regarding that. There's obviously a host of other mental issues, there's a host of other issues in general that we have resources for, that they're not well, or they may be well funded, but they're not well. And even if we have a judgment of inpatient, outpatient earlier, we can give you information for those, and we can't send anybody in there, it's not trying to do anything like that. But we can provide information on any resource you may need. Because we know that a lot of times, just finding the name for one of them can be like jumping through hoops, if you're already juggling everything else, it's just one more thing, even if it's something that. You all showed up today, I'm sure there were plenty of names outside that were called that aren't in this courtroom right now, and that's nothing against them, things happen, right? But you all, I'm sure there's other things that could have gotten in the way of you being here today, but you all are here. You all took the time to show up. And that shows us that we know you work hard for yourself. We know that this is, you take the guys very seriously. And I'm sure there's plenty of other stuff going on that probably needed your attention. But you did. And we want to use that one. I know this is not a place anybody wants to be. This is not a moment anybody's prepared for. But if we can do anything to make it feel more productive outside of here, we want to. That's the only reason we're here.
Maybe this is your first time to be in court, maybe it's your 10th time to be in court, there's still hope. In fact, what we're offering you today has the ability to change your life, but we're gonna need something from you. We're gonna need you to share that need with us so we can see best how to advocate and help you with the situation. Christy explained exactly how you can do that very privately.
So when you guys came in, I can't do this to everybody, but I do need everybody because we are a giant report and we love that. So it doesn't matter if you're here as a defendant, it doesn't matter if you're here as support, it doesn't matter if you need information for yourself or someone not care about. We can just everybody, right? The only thing, this is a baseline type of consent form. The reason it's built this way is that you know the information you put on this form goes straight to me. We're gonna come out there, we're gonna take it out in those seconds. Any information you put on this, protected under state laws and your medical information. The only person who's gonna see this is me or Chloe. The only person who's gonna follow up with you on this is me or Chloe. You will have our phone numbers or work over here, that those numbers will be our direct work line if you need anything. If you put down that you want an email, we will send you email. If you have a specific time of day that works best for a call, tell us. We will do our best to work with them because you have busy lives out there. You have stuff you're managing out there, and we're not trying to add anything that you don't have job. If there's a time or space that we can help in, we want to meet that. You know, on this also, there's the option to speak privately. That everything goes with that. If you want to speak privately, whether you know there's something you need help with, or you want to talk about, or a resource you need to let us know. If you would rather talk to us in a private setting, you can also put that in. Any information on here is only on here so that we can find the best fit resources for you. The only thing that we do with this is look based on what you tell us you need, what you tell us you're looking for, and go off of that. This will never be shared outside of your permission. It will never be given to anyone else, and we can share it after you're done. Besides that, all it is a tool to make it easier for us to get information to you guys and just help. Because I know this is also not a therapy, like I said, not a therapy environment. It's not a place where it's easy to open up in, which is why the options be privately shared, but we also understand if you want to sit down somewhere else. The whole point of this is meeting you where you are, or meeting you what you need, because we're just here to find a way to help. I know I keep saying this, but I really can't because of enough. That's the only reason we're in court, is to find a way to make things easier outside of the court. Because it should not be the first place that most people are offered resources, but unfortunately, a lot of times it is. And the most needed resource that we run across is just support. Maybe you just need someone to talk to about this. Maybe it's things that are normal outside of it, and it's hard to break it down without coming across as, well, we all know how it is, right? If you need help, if you need anything specific, if you start feeling anxious out here in the courtroom, I'm here for that. That's the only reason.
I also have a flyer here that I want to get in everyone's hands before you leave here today. On the back, it tells you some of the advantages of actually participating. But on the front, it also has a 1-800 number. If you're trying to come from an unsafe place, you can call that number and get what you need.
So that's important because it is the first resource we need. As I said, when we contact you, it'll either be mine or Chloe's working direct, another way directly to us. Those work numbers are active from 8 a.m. to 5 p.m. That crisis hotline number is active 24/7. It's active almost statewide too. Because one of the big things is not limited by where you're from. We've worked with people as far as California or Oklahoma. We understand a lot of people in important Jefferson County, so we knew we were close to it. And the reason I say that is active almost statewide, so we also all know that they are several places in Texas where no cell phone service. So, again, people have to call them at 6 a.m. on Tuesday, and they will pick up. If you are in the middle of crisis or someone can run with the whole year, so say we'll get whatever you need set up. If you need information, reach out to us. But it's on to please, want you to have it.
And then shortly, the court is going to go into recess. It does go into recess. We'll be able to come out there. We'll visit with you. We'll pick up those documents. I'll be handing this out to everyone as well. And we'll be able to answer any questions you may have. Thank you very much. Thank you.
Okay.
Thank you, Your Honor.
All right. Thank you, Deputy Henry Chris Floyd. Ladies and gentlemen, I need to give you some additional instructions. The paperwork that you have in your hand, we're going to pick that paperwork up from you. And then we're going to ask that you come up before the bench, and one at a time. We'll call your name, you'll come up before the bench, and we'll go through the paperwork. And then once you finish here, court coordinator will reset your case depending on your choice that the choice that you made on the paperwork. Now, this is going to take us some time to pick the paperwork up and then to go through the paperwork and evaluate it. Now, if you need to use the restroom, there are 2 restrooms outside in the hallway. The male restroom is in front of County Court at Law number 3, which is next door. And the female restroom is on the opposite side of the hall in front of the 172nd District Court. Now, you'll be allowed to go in the hallway. You'll be allowed to use the restroom. Do not leave the courthouse. If you leave the courthouse and your name is called and you do not answer, then your bond may be forfeited. And if your bond is forfeited, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Now, if you need help with anything on that paperwork, we have our court personnel who's here to assist you at completing the paperwork. The folks in Spindletop, they will also come out and talk to you a little bit more. So at this time, the court will go into recess. And those of you who need help, just raise your hand and we'll have someone to assist you with filling the paperwork out. You are. Jefferson County Court, Law number 2 is back in session with the arraignment docket. First case is cause number 23 CCCR 2286. Case is style of state of Texas versus LD A. Lynch. Now, Miss Lynch, your first name is LD. LDD. Miss Lynch, would you please raise your right hand? Miss Lynch, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Miss Lynch, you may put your hand down. How are you doing, Miss Lynch? You doing all right? That's good. Now, Miss Lynch, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? You have to say yes.
Yes,
Is this your signature on the line that's titled defendant?
yes,
Are these your initials on the line that state that you have a court-appointed attorney?
yes.
The name is that John
Coochie.
Coochie Jr.? Okay, now, Ms. Lynch, before you signed and initialed this document, did you read the document?
Yes,
Do you understand what you read?
yes.
Is everything in this document true and correct to the best of your knowledge? Okay, Ms. Lynch, your case is going to be reset to give you an opportunity to have your attorney need to make an appearance, and normally when he makes an appearance, he'll send a letter to the court informing the court that he has been hired to represent you.
And he wanted me to tell you that I have a felony court next week. And he's
So-
working on a deal with.
So you want me to set it on the same, we can, could you, July what? Okay, so this case is gonna be reset with your felony case on July 22nd. Our court coordinator is going to give you your reset. Once you get your reset from the court coordinator, you'll be free to go and you'll have a blessed day. Please have a seat in that first chair on the wall.
You can get your stuff.
That's the 22nd you said? Get Ms. Arachi.
Okay.
Jim, okay.
Make sure you're not flipping in the courtroom.
Yes.
Next case, let's see, is that Thompson? Juan Manuel? Okay, this is cause number 23 CCCR 2232, case is style of state of Texas versus Juan Manuel. Mr. Manuel speaks Spanish, and we have our interpreter, Ms. Jennifer Araji. Mr. Araji, would you please raise your right hand? You swear affirm to tell her to interpret Spanish to English and English to Spanish to help you God.
Yes, sir.
Okay, you may put your hand down. How you doing, Ms. Araji?
Good, Judge. Thank you for asking. How are you?
I'm doing fine, thanks for asking. Ms. Araji, ask Mr. Manuel if his full name is Juan Manuel.
Yes, sir. Nombre completo es Juan Manuel.
Juan, mi nombre completo es Juan. Mi nombre es Juan.
Juan, pero el apellido es Manuel.
Manuel. Sí.
Yes.
Okay. Ask him to raise his right hand. You tell, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes.
Okay, you may put your hand down. You can ask him how he's doing.
Yeah.
Good. All right. Now, Mr. Manuel, let me show him this document. Ask Mr. Manuel if he recognized that document.
Yes.
Okay. And now ask Mr. Manuel if that's his signature on the line that is titled defendant.
Yes.
And ask him if those are his initials on the line that state he would like to have his case reset to hire his attorney.
Yes.
Now, ask Mr. Manuel before he signed and initialed that document, if you, Mr. Raji, went over that document with him in Spanish.
Yes.
Ask him if he understood everything that you went over. And ask him if everything in that document is true and correct to the best of his knowledge. This lady drinking. Okay. Now, Mr. Manuel, I've read your answers. Your case is going to be reset to give you time to hire your attorney. Please stand in front of the court coordinator to get your, hold on a minute. Yeah, please stand in front of the court coordinator to get your reset. Once you get your reset, you'll be free to go and you have a blessed day. And you have a blessed day as well, Mr.
He
Russell.
said thank you. And you.
You are. Thank you. Next case is cause number 24CCCR 0854 case, the style of the state of Texas versus Rashira Jarnay Thompson. Ms. Thompson, your full name is Rashira, is that Jarnay Thompson?
He's right now, Johnny.
Rashira Jarnay Thompson? Okay. Ms. Thompson, would you please raise your right hand? Ms. Thompson, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? So help you God? Okay, you may put your hand down. How are you doing, Ms. Thompson? That's good. Now, Ms. Thompson, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
Are these your initials on the line that state that you have an attorney that you hired named Rife Kimler?
Yes, sir.
Now, before you signed this document, and initialed this document, did you read the document?
Yes, sir.
Did you understand what you read? And is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Okay. Ms. Thompson, I read your answers. Your case is going to be reset. Your attorney, Mr. Kimler, needs to send the court a letter of representation. A letter informs the court that he has been hired to represent you.
Yes, sir.
Do you understand that? All right. You're gonna have a seat. Do you want it to stand in front of you? Or just have a seat in that first chair on the wall. And once your name is called, you go to the wonder. Once you finish at the one, you're free to go and you have a blessed day. You're welcome. Next case is cause number 24CCCR 0816. Case is styled the state of Texas versus Gomez Eric Jose Gonzalez. This country. Mr. Gonzalez. Your full name is Gomez Eric Jose Gonzalez?
Yeah.
Mr. Gonzalez, would you please raise your right hand? Mr. Gonzalez, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Mr. Gonzalez, you may put your hand down. How are you doing, Mr. Gonzalez?
Good.
I'm doing fine, thanks for asking, Mr. Gonzalez. I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes.
And are these your initials on the line that state you want to waive your right to an attorney and represent yourself?
Yes.
I also have a document that is titled Waiver of Counsel for Purposes of Entering Guilty Plea or Proceeding to Trial. Do you recognize this document?
Yes.
And is this your signature on the line that's titled defendant?
Yes.
Okay, now, Mr. Gonzalez, before you signed and initialed these documents that I just showed you, did you read the document? Did you understand what you read? Is everything in these documents true and correct to the best of your knowledge? Okay, Mr. Gonzalez, I read your answers. The prosecutor is going to come out and talk to you about your case. Just please, you go back and have a seat in the gallery. You going to reset on the same day? Okay. Next case is cause number M333678. Case is styled the state of Texas versus Quincy Lance Clark. Mr. Clark, would you please come forward? Mr. Clark, your full name is Quincy Lance Clark.
Sir.
Mr. Clark, would you please raise your right hand? Mr. Clark, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Clark, you may put your hand down. How are you doing, Mr. Clark?
I'm good. Good.
I'm doing fine. Thanks for asking. Mr. Clark, I have before me document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
And are these your initials on the line that state you like to waive your right to an attorney and represent yourself?
Yes, sir.
I also have another document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
Mr. Clark, before you signed and initialed these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Clark, just please, you can go back and have a seat, and the prosecutor is going to come out and talk to you about your case. Next case, the next two cases are cause numbers 23CCCR 2260 and cause number 23CCCR 2312. Both cases are styled the state of Texas versus Ezra Lynn Murray III. Murray, would you please come forward? Mr. Murray, your full name is Ezra Lynn Murray III. Mr. Murray, would you please raise your right hand? Mr. Murray, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God? Mr. Murray, you may put your hand down. How are you doing, Mr. Murray?
I'm all right. What about you?
I'm doing fine, thanks for asking. Now, Mr. Murray, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yeah.
Is this your signature on the line that's titled Defendant?
Yeah.
And are these your initials on the line that state you would like to waive your right to an attorney and represent yourself?
Yes.
I also have another document that is titled Waiver of Counsel for Purposes of Entering Guilty Plea or Proceeding to Trial. You recognize this document? And is this your signature on the line that's titled Defendant? Mr. Murray, before you signed and initialed these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Okay, Mr. Murray, I read your answers. One of the prosecutors, the prosecutor is going to come out and talk to you. You can go back and have a seat.
Was that Ezra Murray?
Yes,
Mr. Murray,
okay. Next, we have, is that Destiny Angelo? Angelo? Okay, now, Miss Angelo, your full name is Destiny Angelo? Miss Angelo, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, Miss Angelo, I have, Miss Angelo, how are you doing? Okay, we're gonna see if we can, now, that's long day working or something? Oh, at school?
Like 30 minutes.
Okay, now, Miss Angelo, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you'd like to apply for court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes.
On page 2 of this same document, there's a signature above the line that is titled Defendant Signature. Is this your signature?
Yes, sir.
Now, Ms. Angelo, before you signed and initialed these documents, did you read the documents? Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay, Ms. Angelo, I read your answers. Based on your answers, you meet the eligibility requirements of a court-appointed attorney, and the attorney that will be appointed to represent you in this case is Attorney Peter Dahl. Attorney Dahl will be given information to contact you, and you will also be given information to contact him. Our court coordinator is going to give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Please have a seat in that first chair on the wall.
Okay, thank
Okay. I mean, if they have one, just set it with them. Okay. Okay. Next case is cause number 24CCCR 0814, case is styled in the state of Texas versus Jace Trooper. Mr. Trooper, your full name is Jace Trooper. Mr. Trooper, would you please raise your right hand? You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Trooper, you may put your hand down. How are you doing, Mr. Trooper? I'm doing fine. Thanks for asking. Now, Mr. Trooper, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature online that's titled Defendant? And are these your initials online that state you'd like to apply for court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document? On page 2 of the same document, there's a signature above the line that is titled Defendant Signature. Is this your signature? Now, Mr. Trooper, before you signed and initial these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Trooper, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. The attorney that will be appointed to represent you is Attorney Mark Faggart. Attorney Faggart will be given information to contact you. You will be given information to contact him. Now, the court coordinator is going to give you that information, but before she gives you that information, I need to give you some bond conditions. Let's see, yes. Mr. Trooper, the bailiff is handing you a document that is titled Standard Bond Conditions in County Court at Law Number 2. Do you see that document?
Yes, sir.
Okay, I'm going to go over this document with you. The document states that following the return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Right. So.
Yes, sir.
Okay. Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs, alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
Yes, sir.
And condition number 4 does not apply. That only applies in the DWI case. However, condition number 5 does apply. And condition number 5 states the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer, as defined by section 1.07 of the Texas Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes, sir.
Now, Mr. Trooper, if you violate any one of these conditions, your bond can be revoked, and if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand?
Yes, sir.
Now, Mr. Trooper, how old are you?
I'm 18, May.
Okay, so you're 18 years old. And Mr. Trooper, I see that, let me tell you this here, a lot of times, young folks tend to say that, they have friends, and they tend to say that their friends have their back. And that's like, I think y'all say that, that's my ride or die.
Yes, sir.
In essence, if whatever goes down, whatever trouble I get into, they got my back.
Yes, sir.
They'll be with me. But I noticed something today. I see 3 people in here that's with you.
Yes, sir.
Now, who are those individuals?
Well, already that I've been since a couple of months now, I've been helping with cancer too.
Okay,
Yes, sir.
so you have your mom, stepmom, and the lady that you've been with for a couple of months,
Yes, sir.
right?
Cancer, Caesars.
Okay,
I do a lot of lawn work for her.
okay.
And,
Well, that's good. Now, let me tell you this here. That's your ride or die. Those 3 people right there. Okay? That's the people that put roof over your head, clothes on your back, food on the table. They're here with you today.
Yes, sir.
Okay, those other people that you say that's your friends and your partners, they're not here.
Yes, sir.
They're not here. They're not your ride or die. And I tell people this all the time. Everybody not your friend. Everybody not your partner.
Yes, sir.
But when those 3 people say they got you, they got you.
Yes, sir.
And so that's the people that you need to listen to. They have your back. Okay. Now, Another thing that you said that I like was you cut grass. Well, that's good. I remember growing up cutting grass. I think we used to cut grass, go around people's house, knock on their door, tell them, we'll cut the grass. Where I came from, we didn't have no yard, we didn't, my parents didn't have no yard boy.
Yes, sir.
Me and my brothers was the yard boys.
Yes, sir.
We cut the grass, okay? And so you can learn a lot. And what I'm trying to say is this here, that life is a journey, okay? It's not a destination, it's a journey. And along that journey, everything that you're doing now is going to be meaningful later on. The experiences that you get from cutting grass, the experience that you get from taking care of that young lady, and the experience that you get from those people supporting you, that's going to go a long way in developing the person that you are.
Yes, sir.
Okay. And I see this already started because you have a good heart, because you're taking care of someone who is not able to take care of themselves. Okay.
Correct.
So that's a good thing. So I can see one thing, that you have compassion in your heart.
Yes, sir.
Okay. And that's going to bring you a long way. Okay. A good reputation will carry you further than money will bring you.
Yes, sir.
That's what I learned. Your reputation of being caring and a compassionate person is going to bring you a long way.
Yes, sir.
Okay, so keep up the good work. We have been appointed an attorney.
Yes, sir.
You can talk to your attorney about your case. He can tell you about the programs that we have here in County Court at Law Number 2 that I mentioned to you all earlier. And if you're interested in any one of them, just let us know. We have some brochures.
I'm interested in getting my GED and
Oh.
kind of welding program.
Oh, good. Let me get this to you then. That's good. Your education is a passport to your future. Okay? Here we go. This is a brochure to that CICE program that's at Lamar University, where you can get some job training and job placement. Okay? That help you to continue to be a productive person in our community. All right? Okay, Mr. Trooper? Oh. Just have a seat in that first chair. And then when you go up to the window, when your name is called, when you finish the window, you're free to go. You have a blessed day. And y'all, thanks for coming here and supporting Mr. Trooper. Okay, and y'all have a blessed day too. Next case, Pamela Bowie. Ms. Bowie, you can put your purse and your paperwork on that table. Ms. Bowie, your full name is Pamela Bowie.
I'm looking up.
How you doing, Ms. Bowie?
Was it happening bad?
Okay, I'm sure you've been worse too. But it's a good thing, that's right, you're still here. This is the day the Lord has made. Let us rejoice and be glad in it. All right. Now, Ms. Bowie, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
No, I wanted to call the phone.
I don't know, but I'm saying that. Just listen to my question. The document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? Is this your signature on the line that is titled defendant? Are these your initials that state on the line that state you would like to apply for a court-appointed attorney?
Yes, sir.
All right. Now, I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
And on page 2 of this document, there's a signature above the line that's titled Defendant Signature. Is this your signature?
Yes, sir.
Okay. Now, before you sign and initial these documents, Did you read the document?
I did.
Did you understand what you read?
Yes, I did.
And is everything in these documents true and correct to the best of your knowledge?
Yes.
Ms. Bowie, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. An attorney that will be appointed to represent you is Attorney David Grove. Attorney Grove will be given information to contact you, and you will be given information to contact him. Now, before I give you that information, the bailiff need to hand you a document that is titled Standard Bond Conditions in County Code at Law Number 2. And Ms. Boyd, do you see that document?
Yes.
I'm going to go over this document with you. Ms. Boyd, this document states that following return of a criminal information in County Code at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition, Ms. Boyd?
Yes, sir.
And condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
Now, condition number 3 states, the defendant shall not communicate, either directly or indirectly, with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
Yes, sir.
And condition number 4 does not apply because that only applies in the DWI case. Your case is not a DWI case. However, condition number 5 does apply. Condition number 5 says the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer, as defined by section 1.07 of the Texas Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
And I forget rid of it.
Or you can't not have possession of any firearm ammunition. Do you understand that?
Yes, sir.
Okay, now,
I
Miss,
can get by my phone.
well, let me do this here. I can't give you any legal advice. Only thing I can tell you is that,
I'm saying
if you
I have
violate-
for my protection,
Okay,
if I stay alone.
but you could talk to your attorney about that. Like I said, based on this here document, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, a warrant will be issued for your arrest. Now, Ms. Boyd, as I mentioned to you earlier, you qualify for court-appointed attorney David Grove. You're gonna have a seat, and if she's ready, you can go to her window. She's gonna give you a reset. Once you get your reset, you're free to go, and you have a blessed day. Thank you. You can go, you're gonna go back that way. She's gonna give you your reset.
Okay.
Yeah, he should be contacting you in the next, 24 hours? And if he doesn't contact you,
So I would have to contact him.
oh, okay.
And I'm sure it'll be.
His number,
Back on tomorrow, but,
his number is on there. Yeah,
okay,
okay,
all right, I'll give him contact.
All right. okay. You have a blessed day.
Likewise.
Next case is cause number 24CCCR 0926, case of style of State of Texas versus Lee Ann Sherman. Did I? Oh. Oh, yeah, thank you. All right, Ms. Sherman, your full name is Lee Ann Sherman?
Yes, sir.
How are you doing, Ms. Sherman?
I'm fine.
Okay, Ms. Sherman, would you please raise your right hand? Ms. Sherman, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Ms. Sherman, you may put your hand down. Now, Ms. Sherman, I have before me 2 documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled
Yes,
defendant?
sir.
Are these your initials on the line that state you'd like to
Yes,
apply
sir.
for a court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
And on page 2 of this same document, there's a signature above the line that's titled defendant signature, it's just your
Yes, sir.
signature. Now, Ms. Sherman, before you sign and initial these documents, did you read these
Yes, sir,
documents?
I read.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of
Yes,
your
sir.
knowledge? Okay, Ms. Sherman, I read your answers. Based on your answers, you meet the eligibility requirements of for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Benjamin Jeffries. Attorney Jeffries will be
Yes,
given
sir.
information to contact you,
Yes, sir.
and you will be given information to contact him. Our court coordinator will give you that information. But
Okay.
before she gives you that information, I need to give you some bond conditions. And Ms. Jackson, could you hand these
I want
bond?
that JED paper too.
Okay. Give her the bond conditions.
Yes, sir.
Okay, now, Ms. Sherman, you can step back in front of the bench. Now, Ms. Sherman, I'm going to go over that document with you.
Okay.
That document states that standard bond conditions in County Court Law number 2. Following the return of a criminal information in County Court Law number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
And condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs, alcohol in the defendant's body. You understand that condition? And condition number 3 does not apply. Condition number 4 does not apply. However, condition number 5, 6, and 7 does apply. Condition number 5 states that defendant will obtain and participate in the Spindletop ATAR program, Addiction Treatment and Recovery Program. Do you understand that?
Yes, how long y'all want me to do this?
Well, it's you along your own bond.
Cause I just did this too. I just did this recently.
Okay. Now, and you would 6 remain drug and alcohol free. Do you understand that condition?
I did 6 months already.
Okay, and then you will participate in the ATAR program, the ASAP program with Spindletop Center, 2750, what is that?
Yeah.
South 8th Street, Beaumont, Texas, Building C 77701. Do you understand that?
Exactly.
All right. Now, if you violate any one of those conditions, your bond can be revoked. And if your bond is revoked, a warrant will be issued for your arrest. And Ms. Sherman, I'm going to give you a copy of information with the CICE program
Yes, sir.
that they can assist you at getting your GED. And if you would like to participate in a job training and placement program, you can participate in that as well. This is a document. There's a number down here that you can call.
All right.
And you can step over there in front of, oh. What do you do?
Oh, my God.
Well, let me tell you this here. You can come back up here.
Yes.
Now, Miss Sherman,
Yes, sir.
the road to recovery is not a sprint.
Yes, sir.
It's a marathon.
I just did it from CPS and
Okay,
everything, so
that's what I'm
I
saying.
just-
But you know the difference
Yes, sir.
between a
I'm
sprint
already
and a
aware.
marathon?
I'm already aware.
Okay, now, sprint is a short race, a marathon is a long race.
Yes, sir.
Okay, now as if you know as well as I do, from having run long distance races,
Yes, sir.
you get tired along the way.
Yes, sir.
But when you get tired along the way, there's some people that you can lean on for support.
Yes, sir.
The people in the Spindletop program,
Yes,
the
sir.
people in the CPS,
Yeah, yes, sir.
family members who are trying to help you, and friends. So that's the reason why we have this program,
Yeah, yes, sir.
because we know you can get tired along the way. And you know how long the road to recovery is?
Well, it's a journey.
And how long is it?
Well, I did 6 months already.
It's a lifetime.
Yes, sir.
Okay. And so this is a thing that we're going to be dealing with the rest of your life.
Yes, sir.
It's a lifetime. And so we're going to try to give you all of the support that you need so that you can continue successfully on this journey.
Yes, sir.
All right. All right.
Thank you. I
All right.
appreciate you.
You can stand over there and you have a blessed day.
Yes, sir. Thank you. I appreciate it.
You're welcome.
Oh, my God. Come see these people. Yes.
Hold on a minute.
16,
The next case is cause number 24 CCCR 0910, case is styled the state of Texas versus Tory Javon Willis. Mr. Willis, pull up your pants. You need to get tie that deal to hold your pants up. Now, Mr. Willis, your full name is Tory Javon Willis.
Yes,
Mr. Willis, would you please raise your right hand? Mr. Willis, do you swear or affirm to tell the truth, to hold true, and nothing but the truth, so help you God?
yes, sir.
Mr. Willis, you may put your hand down. How are you doing, Mr. Willis? I'm doing fine, thanks for asking. Mr. Willis, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled defendant?
Yes, sir.
And are these your initials on the line that states you'd like to apply for court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Injuries. Do you recognize this document?
Yes, sir.
On page 2 of the same document, there is a signature above the line that is titled defendant signature. Is this your signature?
Yes, sir.
Mr. Willis, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct
Yes, sir.
to the best of your knowledge? Mr. Willis, I read your answers. Based on your answers, you meet the eligibility requirements for a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Todd LeBlanc. Attorney LeBlanc will be given information to contact you. You will be given information to contact him. But before I give you that information, the bailiff need to hand you some bond conditions that I'm going to go over with you. Mr. Willis, do you see that document that's titled Standard Bond Conditions in County Court Law Number 2?
Yes, sir.
Ma'am, that door is locked. You got to go through the other door. And that document reads as follows. Following return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And condition number 3 and 4 does not apply. However, condition number 5 does apply. Condition number 5 states as follows. The defendant is prohibited from possessing a firearm ammunition unless the defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that?
Yes, sir.
Now, Mr. Willis, if you violate any one of these conditions, your bond will be revoked. If your bond is revoked, the warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand?
Yes, sir.
Now, Mr. Willis, you're gonna have a seat on the first chair on the wall. Wait for your name to be called. Once your name is called, you'll go to the window of the court coordinator. Once you finish at her window, you're free to go, and you have a blessed day.
You too.
Next 2 cases are cause numbers 23 CCCR 2310, cause number 23 CCCR 2311. Both cases are styled the state of Texas versus Roderick Lanier Tillman Jr. Mr. Tillman, your full name is Roderick Lanier Tillman Jr.
Yes.
Mr. Tillman, would you please raise your right hand? Mr. Tillman, do you swear or affirm, tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Tillman, you may put your hand down. How are you doing, Mr. Tillman? That's good, Mr. Tillman. I have before me 2 documents. First document is titled Judge's explanation of rights to defendants without attorney. Do you recognize this document?
Yes.
Is this your signature on the line that's titled defendant?
Yes.
And are these your initials on the line that state you'd like to apply for court-appointed attorney?
Yes.
I also have another document that is titled Douglas County Affidavit of Indigence. Do you recognize this document?
Yes.
On page 2 of this same document, there's a signature above the line that is titled Defendant Signature. Is this your signature?
Yes, sir.
Mr. Tillman, before you signed and initialed these documents, did you read the documents?
Yeah.
Did you understand what you read?
Not necessarily. I mean, I have no choice.
Okay, you must not have been listening to me. I used the word, no, listen to me.
No, you
Okay, what did I say just now?
said, listen, I understand.
Okay, listen means don't talk. Okay, that's why God gave us 2 ears and 1 mouth. Okay, so I told you earlier, you said you felt like you had to do it. Well, there's a word there was a word here saying voluntarily. I said, and voluntarily means that nobody's forcing you to do it. You're doing it under your own free will. Do you remember me explaining that to you? Okay, that's what it meant. Now, what I'm going to do is I'm gonna give you these documents back. The main document is judge's explanation of rights to defense when I'm attorney. You're gonna sit at that table right there, you read it and read these documents. If you need any assistance, we have our court personnel here who will be able and willing to help you. And then once that's done, I mean, if this is not what you want to do, the choice that you make, you want to change your mind.
Like, honestly, your mom was kind of like explain to you because like when this situation happened.
Oh, let me do this here.
I can't just.
No. You have a right to remain silent. You have a Fifth Amendment right against self-incrimination. I think I mentioned that to you too. And that means you have a right to remain silent. You know, you watch television, you hear people saying, I take the fifth. That means I'm not gonna say nothing. Why? Because anything that you say can and will be used against you in the court of law. Okay? You have a right to have an attorney. If you can't afford one will be appointed to represent you. Okay? So anything that you want to discuss about your case or talk anything you want to say about your case, you can tell that to your attorney because your attorney is the person that represents you. I don't represent you. Bailiff don't represent you. The prosecutor doesn't represent you. Nobody in this court represents you. Okay. So,
I mean, like,
so I can't talk.
Up about somebody having.
Well, let me just okay, Mr. Tillman.
I got charged with-
Mr. Tillman, I see you have a problem in following directions.
I can follow directions.
You're not following directions. I told you you had a right. You cannot speak right now because you have a right against self-incrimination. Now, you have a right against self-incrimination. Do you understand what that means? Anything that you say can and will be used against you in the court of law. So whatever you say here today, the state can write that down, get a copy of this thing off of YouTube, right? And while you're in trial saying something different, they're going to pull this up and use it against you. Okay? You're going to have an attorney. Okay. Your case is not going to be disposed of today. Okay? And so that's why you have an attorney, somebody who is experienced and trained in law to help you. Okay? That's the purpose of getting an attorney. Now, what we're going to do is, like I said earlier, we'll give you an opportunity to review the document. And if there's something that you don't understand in this document, then we have our court personnel who will be happy to explain it to you. Okay, so that you can make the choice that you would like to make. Nobody is forcing you to choose whether or not you want to hire an attorney, whether or not you want to court appoint an attorney, or whether or not you want to represent yourself. That's a choice that you have to make. Okay? So just have a seat and on that table right there.
I ain't gonna lie, man, it's cool. I'm gonna just roll what I had put on paper. Like, I mean, I mean,
Okay, I understand you say you're gonna run what you put on paper, but what you told me is that you didn't understand everything, and I can't go forward with what you put on paper because
You know what I mean?
because because you said that you felt like you had to sign it. Okay, that sounds like somebody
Yeah,
is
you know
you
what I
was
mean?
forced to
Because
sign it.
you know what I mean? Because I mean, like I feel like if we could have like had a discussion about everything, and then you know what I mean, and then like get to the paper and get to sign it. You know what I mean? Because like I mean, I ain't had no clue. Look, like I ain't gonna be real with you. All this stuff right here really new to me. Like I don't got no.
That's why I took my time. Okay, it's new to most people in here. That's why I took my time to explain it to you. Now, if you would like us to go over it again with you, that's not a problem. That's what we're here for. Okay, we're not trying to railroad nobody. Okay, we're not trying to rush to judgment. Okay, we're trying to let you understand that you have rights, right? And we're not going to violate your rights or trample upon your rights. Okay, so we're just gonna take our time. Okay, all right. So just have a seat at that table and we'll have someone to help you if you need some assistance. Okay, now let's see. I think we had Mr. I think I'm gonna go. Yeah. Quincy Clark. Who's that? Okay. Okay. Now, Mr. Clark, you were here earlier before the bench, and you had an opportunity to talk to the prosecutor about your case. Is that correct, Mr. Hubel?
That's correct, Ron.
And what is the agreement that you have reached with the defendant?
Your Honor, the state discussed the offer with the defendant. And the one thing that he pointed out to me was that, part of the state's offer was restitution, and he said that he had already paid said restitution to the complaining witness. The state would like time to
Okay,
confirm that.
so the state is going to verify that you paid restitution to the complaining witness, and so your case is going to be reset. That means we're going to give you another court date to give the state time to just give them a standard 30 days. We can put him on an announcement docket. You don't have to be on an arraignment. Just probably put him on. Now, let me ask you this here. Do you work?
I got an interview today.
Okay, because I was just wondering which day of the week was better for you, Monday through Friday. Thursdays are not good because, what about a Friday? Okay, yeah. Okay, this case is gonna be reset to August 16th, 2024. The state gonna verify that you paid restitution to the victim. Okay, so have a seat in that first chair on the wall, wait for your name to be called. Once your name is called, you're free to go. And you have a blessed day. Yes.
I can ask you a question.
Okay, it can't be about you, I can't give you any legal advice or anything.
I asked, I want to get you to show, like, how long do it stay on my record?
Well, you can probably talk to an attorney about that. Right now, the state can get the is need to get that information. They need to verify.
All right,
Okay.
thank you.
All right. Okay.
Oh, sorry.
Okay. I'm gonna need.
Yeah.
Step Clark?
Mr. Tillman? Okay, now, Mr. Tillman, you was previously sworn in, is that correct? Okay, now, Mr. Tillman, you acknowledge that you recognize this document, is that correct?
Yes.
And it's your signature on the line that's titled defendant? And these are your initials on the line that state you'd like to apply for court-appointed attorney, is that correct? You also acknowledge that you recognize this document, Jefferson County Affidavit of Injuries, and that on page 2 above the line that is titled defendant, that this is your signature, is that correct?
Yes.
Now, before you signed and initialed these documents, did you read the documents?
Yes.
Did you understand what you read?
Yes.
And is everything in these documents true and correct to the best of your knowledge? Okay, now, Mr. Tillman, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you in this case is Attorney John Macy. Attorney Macy will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Please have a seat in that first chair on the wall.
Thank you.
You're welcome.
May I have one thing, Ms. Gomez? You don't know?
Gomez, would you come on up? Now, Mr. Gonzalez, you wanted to change your choice on this document
Yes,
from
sir.
wanting to waive your right to an attorney and represent yourself. Is that correct?
Yes, sir. Do
Oh.
some changes.
Okay, Ms. Bailey? Did you hand this document back to Mr. Gonzalez so that he can make his change? If he wants to hire his own attorney, he would put his initials on the first line at the top, and you mark a line through the previous choice. Ms. Bailey? Now, Ms. Gomez, your choice is to have your case reset to hire your own attorney?
Yes, sir.
Okay, now you was previously sworn in, is that correct?
Mhm.
Everything on this document true and correct to the best of your knowledge?
Yes, sir.
All right, now, Mr. Gomez, your case is going to be reset to give you an opportunity to hire your own attorney. But before that is done, I need to hand you, the bailiff need to hand you some bond conditions. Ms. Bailiff, could you hand these documents to Mr. Gomez? I mean, to Gonzalez, excuse me, Gomez Gonzalez. Okay, now, Mr. Gonzalez, the bailiff has just handed you a document that is titled Standard Bond Conditions in County Court Law Number 2. Do you see that document?
Yes, sir.
And I will go over this document with you, and it reads as follows: following the return of a criminal information in County Court Law Number 2, all bail bonds executed for release of any defendant named herein, the defendant shall commit, okay, number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to the test of drugs and alcohol when directed to do so by the court, or B, submit to a test of drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And condition number 3, the defendant, condition number 3 does not apply, and condition number 4 does not apply. However, condition number 5 on the second page does apply. Condition number 5 states, the defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes, sir.
Now, Mr. Gomez, if you violate any one of these conditions, your bond will be revoked. And if your bond is revoked, a warrant will be issued for your arrest. Do you understand that? Okay. Now, Mr. Gomez Gonzalez, your case will be reset by our court coordinator. Once the case is reset, you'll be free to go, and you have a blessed day. Please have a seat on that third chair on the wall. Ms. Bailiff, I need a copy. I need a copy of my bond conditions.
But everything, there's one, everything already.
Gibson County Court at law number 2 is back in session. The court is in session and calls numbers 23 CCCR 2260 and calls number 23 CCCR 2312. Both cases are styled the state of Texas versus Ezra Lynn Murray III. Mr. Murray, would you please come forward? Okay, now, Mr. Murray, you were previously sworn in, is that correct?
Yes, sir.
And initially, you stated that you wanted to waive your right to an attorney and represent yourself.
Yeah,
Is that still your choice, or have you changed your mind?
I mean, I get a court appointed.
Okay, let me hand this document back to you. And the bailiff is going to hand that document back to you. You could make your choice on the appropriate line.
Yeah, but, you know, and,
I mean, what you say is it?
yeah, 'cause I thought it would be more simple than that was.
Okay, now, Mr. Murray, uh, again, you were previously sworn in, you've changed your mind. Now you place your initials on the line as, oh, let me do this. Okay. Place your initials on the line that states you like to apply for court appointed attorney, is that correct?
Yes, sir.
Okay,
Was there, oh, was it already filled out?
Murray, he didn't fill out after,
No.
no, we need to give him a document. Just have a seat at that table right there.
I'm definitely the first that he needs,
You fill out the first two pages on that Jefferson County affidavit, it's the 3-page document now. He made this change on that one, right here,
so the engine,
Jefferson County affidavit of indigence.
and the oath.
Yeah, it's 3 pages to that one document.
Now we bring you in.
Yeah, you're gonna fill out the first page and half of the second page. Okay, normally, okay, this is cause number 23 CCR 2312, cause number 23 CCR 2260. Both cases, Styles of State of Texas versus Ezra Murray the third. Ms. Murray, would you please raise your right hand? Ms. Murray, do you swear firm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Murray, you may put your hand down. Now, Mr. Murray, you previously chose to waive your right to have an attorney and represent yourself. However, you have changed your mind. Now, your choice is to apply for a court-appointed attorney. Is that correct? Now, is this your signature on this document?
Yes, sir.
And are these your initials on the line that state you'd like to apply for a court-appointed attorney?
Yes, sir.
Now, I know Mr. Murray, you were stating that when you were arrested, you thought that you had an attorney appointed. You had applied for one. Now, normally what happens is you apply for an attorney, and if the attorney is not appointed prior to the time that you bond out,
Yeah,
then you will get an attorney appointed in your first court appearance,
okay,
which is
today.
today. Okay, so Mr. Murray, I have another document before me that is titled Jefferson County Affidavit of Indigence. You recognize this document?
Yes, sir.
On page 2 of this document, there's a signature above the line that is titled Defendant Signature. Is this your signature?
Yes, sir.
And Mr. Murray, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in this document true and correct to the best of your knowledge?
Yes.
No, Mr. Murray, I read your answers. Based on your answers, meet the eligibility requirements for the appointment of a appointed attorney, and the attorney that will be appointed to represent you in your case is Attorney Reagan Minaldi. Attorney Minaldi will be given information to contact you, and you will be given information to contact her. Our court coordinator will give you that information. Now, before she gives you that information, hold on a minute. Before she gives you that information, the bailiff is going to hand you a document that is titled Standard Bond Conditions in County Court at Law number 2. Mr. Murray, do you see that title
Yes, sir.
on that document? Now, Mr. Murray, I'm going to go over this document with you. And this document states as following: following the return of criminal information in County Court at Law number 2 of Jefferson County, Texas, all bail bonds executed release of any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or against the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs or alcohol in the defendant's body. Mr. Murray, do you understand that condition?
Yes, sir.
And condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Mr. Murray, do you understand that condition?
That part I would not know because I don't even know the victim.
Okay,
I understand what you're saying though. I completely.
okay, so you cannot be around the victim. Okay, now, condition number 4 does not apply. Condition number 5 does apply. Condition number 5 states the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a full-time, sworn, paid employee of a state agency or political subdivision. Mr. Murray, do you understand that condition?
guess.
Okay,
I don't know.
okay. My question is, do you understand it?
Yeah.
Okay, hearing me and understanding are two different things. I didn't ask if you heard me. I mean, you probably had to hear me before you had to
So,
understand.
so in this, in number 5 saying, I can't possess or carry my own firearm.
We're saying that as a defendant and as a condition of your probation, you are prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by section 1.07 of the Penal Code actively engaged in employment as a sworn full-time paid employee as a state agency or political subdivision. That's a condition of your release on bond. Do you understand that?
Yeah, I get it.
Okay.
That's crazy.
Okay, so the court has an obligation to ensure, to protect the safety of the public.
I gotta protect my safety too. I ain't
Okay.
worrying about nobody else but my safety.
Okay, I'll tell you one thing, you possess of ammunition or firearm, you'll be arrested, placed in the Jefferson County Jail. Do you understand that?
We just have to go through that, we get to.
Okay. Now, Mr. Murray, do you understand the conditions of now, because you're charged with two cases. You have a terroristic threat and causing fear of imminent bodily injury, serious bodily injury. And the second case you have is unlawful carrying a weapon. Do you understand that?
Understand first.
Okay, well, that's what you're charged with. You understand with those are the two cases that you're charged with. So if you violate any one of these bond conditions, your bond can't be revoked. And if your bond is revoked, you will be arrested and placed in the Jefferson County Jail on these cases. Do you understand that? Yeah. Okay. Now, Mr. Murray, your case is going to be reset. Please stand in front of the court coordinator and she'll reset your case.
You don't have to be.
Hmm?
I'm gonna make this-
Hey, now, Mr. Murray, let me tell you this here. This court, or any court, has decorum. And what I mean by decorum, you have to conduct yourself in such a way where you not be disruptive to the court. If you do not conduct yourself in a way that you cannot be disruptive to the court, you could be held in contempt of court. And if you're held in contempt of court, this court can place you in jail for 6 months and order that you pay a fine of $500. Do you understand that? Okay, so if you do not conduct yourself, the court is going to hold you in contempt and you're going to be placed in Jefferson County Jail for 6 months.
But should you receive the dismissal on Pierce?
I sent it. I sent it back. Elizabeth Joe Pierce.
Yes, Your Honor, thank you.
Yeah. So we have one case left. Bound forfeiture. Okay. I see Smetley. Who is the second case? Who is the second case? Who?
Page 4.
Page 4.
Yes.
Stevens? Oh, yeah, okay. Okay. Hmm. Jefferson County Court at Law number 2 is back in session. The court is in session in cause number 24-CCCR 0838. Case is styled the state of Texas versus Smedley Ishmael Humphreys. Ishmael Humphreys was scheduled to be in court this morning for the arraignment at 9 a.m. At or about 9 a.m., the court's bailiff called the name of Smedley Humphreys at the courthouse door. Smedley Humphreys did not answer. Smedley Humphreys has not appeared in court since the court has been in session. The time now is 12:43 a.m. 12:43 p.m. on the day's date. Ms. Bailiff, would you please call the name of Smedley Humphreys at the courthouse door?
No response, Your Honor.
Smedley Humphreys' name was just called again at the courthouse door. Smedley Humphreys did not have a reasonable time has passed to give Mr. Humphreys the opportunity to appear in court. He's not appearing in court. State, do you have a motion?
Distinguished from forfeiture.
That motion will be granted. Smedley Humphreys' bond will be forfeited and warrant should be issued for his arrest in cause number 24-CCCR 0838. Next case is cause number 24-CCCR 0862. Case is styled the state of Texas versus Tyler Stevens. Tyler Stevens was scheduled to be in court this morning at 9 a.m. for the arraignment docket. At or about 9 a.m., the court's bailiff called the name of Tyler Stevens at the courthouse doors. Tyler Stevens did not answer. A reasonable time has passed to give Mr. Stevens an opportunity to appear in court. He has not appeared in court. And the time now is 12:44 p.m. on today's date of July 16 of 2024. Ms. Bailiff, would you please call the name of Tyler Stevens at the courthouse door?
Yes, sir. Tyler Stevens. Tyler. No response, Your Honor.
Tyler Stevens' name was just called at the courthouse door. Tyler Stevens did not answer. A reasonable time has passed to give Mr. Stevens an opportunity to appear in court. State, do you have a motion?
Distinguished from forfeiture.
That motion will be granted. Tyler Stevens' bond will be forfeited and the warrant should be issued for his arrest in cause number 24-CCCR 0862. And this will conclude the calling of the arraignment docket on today's date of July 16, 2024 in County Court at Law number 2 of Jefferson County, Texas. Judge Terrence L. Holmes presiding. Everyone, please have a blessed day. And Mr. Hubel, you are free to go and you have a blessed day.
Thank you, Judge.
You're welcome.